Welcome back to the OMB Law Board. I'm Simon Bennett, and today I've got Samuel Layani from our litigation team. Samuel, welcome back to the podcast.
Thank you. Thanks for having me again.
So, Sam, I'm going to intersect two worlds here. I want to talk about caveats. That's right, caveats. And we're going to explain to you exactly what a caveat is. It's a term you may have heard. It's a very legal term, but it intersects really my area, property, and your area, litigation.
Absolutely. The two intertwine within each other.
Yeah, so it's a caveat is a very property-dominated tool because it deals with property, but it is used extensively in litigation, debt recovery, protecting interests.
Absolutely. I would say the first part of a caveat is very property heavy, and everything that comes after the lodgement of the caveat would then be very litigious, and the way things happen and transpire after it.
Okay, so let's dial it back. What is a caveat?
A caveat is a document which is lodged with titles which vests an interest in a property. So an individual might have a vested interest in a particular property, so they'll lodge a caveat on title to assert such an interest in property.
So one of the questions we get asked, particularly in the property team or not, is can I lodge a caveat? So how do I know when I can lodge one and when I can't?
Well, it's a bit of a tricky question, actually, because it all stems down to what is your interest? Do you have a vested interest in the property? You need to also go behind, is there a document that gives you a vested interest in a property? For example, did you sign a loan agreement, for example, and is there a personal guarantee within that loan agreement vesting all of your personal property in a or giving a charge, for example. So that is a way in which you can determine if you have a caveatable interest.
And that's the term, isn't it? That's a term we often use is I've got to determine, do you have a caveatable interest? And quite often that caveatable interest has to be a specific charge on the land. So a specific document usually, which says, you know, I, Simon, charge all of my land to you, Sam, as security for the money you've lent me or the provision of services or what have you.
That's right. That's exactly right.
Obviously, there's other situations, including matrimonial. There might be a constructive trust or things like that. It's quite a complex area, which we won't delve into too much today. Other than I'll say this, is if you want to know if you've got a caveatable interest, you need to ring a solicitor. You ring one of our team here at OMB and we will walk through what you've got and whether that constitutes a caveatable interest.
Absolutely. And you also don't want to take a step to assert you have a caveatable interest and in fact you do not.
Because what happens if you don't?
Well, you know, there's legal ramifications that will follow that. If you do lodge a caveat, someone can give you notice to commence a legal proceeding and within 14 days you have to do and commence a legal proceeding. And if you do not do that, your caveat will lapse. So you've asserted an interest in a property and that interest has now transpired.
And if you didn't have a caveatable interest, but you sought to lodge a caveat and that prevented me from doing something and I suffered loss and damage,
then I, as the person lodging the caveat, would be entitled to pay that loss and damage or be required to pay that loss and damage. You don't want to bark up the tree where you might render yourself in a position where you are suffering loss and damage or causing loss and damage to someone else because then that person can come after you for that particular loss and damage.
And there's quite often an undertaking as to damages when you lodge this caveat that you will, you know, cover those costs if you're subsequently proven not to have that right.
And unsuccessful, absolutely.
Okay, so that gives us a little bit of a background as to what this caveat is. How does it work and what does it do when you lodge it on my property?
So the way it works and when it's lodged on the title to the property is it'll come up as that there is a particular caveat with a dealing number. And the way it works is it means that the person who owns the property or is the proprietor to the property can't deal with that property due to the caveat being there. You can't refinance, you can't settle if you're going to through the conveyancing process, and you have to deal with that caveat in first instance before you can deal with your property in the way you wish to deal with it.
So the notification or the registration of the caveat on title is a notification to the world that I have an interest in that property, and that registered owner is now prevented from dealing with that property in any way. So they can't sell it, they can't remortgage it, they can't lease it and register an interest, etc. So it's quite restrictive.
It's very restrictive.
Okay. And in a litigation sense, how is the use of these caveats becoming more prominent?
Well, in a litigation sense, they are becoming prominent because, especially in some recent examples where we've been dealing with large developments, they're asserting interests in a property and it's causing loss and damage to a developer, for example, then becomes a inflamed situation over a very small monetary sum. And legal proceedings then are commenced and transpire, and the costs far outweigh sometimes the caveat itself, the caveatable interest itself.
So people are using it as a leveraging tool to recover a debt, etc.,
absolutely,
and preventing a much larger project taking action.
I think a method of exerting commercial pressure in circumstances where there might be a dispute between the parties, and there has been an increasing number of caveats used in those circumstances to exert commercial pressure to push towards a resolution or obtain a settlement in respect of an issue that might be on a loan document, etc.
And conversely, I guess, Sam, if you were acting for someone who was owed monies or compensation, for example, under an agreement which had been breached, that did give you the right to lodge a caveat. You could use that as a tool to assist in the recovery?
Absolutely.
And how would you go about that?
Well, first of all, you would, if you needed to lodge a caveat or thought you had a caveatable interest, you first of all take instructions from a solicitor to make sure you do have one. And then you will obviously lodge your interest on title. But lodging your interest on title to the property, you have to be prepared to be met with a notice to commence a proceeding to assert your interest under that particular caveat to which you've lodged on title. So it's not just a matter of lodging a caveat, oh, okay, I've got my interest vested in that property. You have to be prepared to take the next step, the extra mile, in commencing a legal proceeding to then assert the loss and damage that you might have suffered.
And a caveat, in a general sense, other than consent, where it's given by consent, where I forcibly lodge a caveat in your property, it's got a time limit to it, doesn't it?
Caveats lapse within 90 days, 3 months, and then they will remain on title until they're removed.
So obviously a caveat doesn't last forever. You've said it's 90 days. Obviously, if I start or commence an action with that, that can preserve it.
That's correct.
And there's other mechanisms to speed that 90 days up.
Absolutely. So if you lodge or give notice, rather, they have to commence a proceeding within 14 days.
So I can shorten that back, right?
You can shorten that period back from 3 months or 90 days back to 14 days. But something you have to also ensure is just because you've lodged a proceeding doesn't make it clear that your caveat is maintained on title. You have to give or deposit with the registrar notice that you have maintained that interest by lodging proceedings.
So the notification of action.
Notification of action.
Yeah,
that's correct.
Okay, so they're quite technical.
Yes.
Obviously, we understand, our listeners and viewers, hopefully we've given you a little bit of an insight as to, number one, what is a caveat, how it can be used either against you or how you can use it to enforce your rights.
And your advantage, absolutely.
And Sam, you and the litigation team here at OMB are very knowledgeable and experienced in the use and defence of caveats?
Yes, we've been dealing with them a lot lately, and we've had some great success in using caveats for individuals and also on the other spectrum as well.
Getting them removed.
Getting them removed, absolutely.
Fantastic. Well, Sam, thanks so much for coming in and talking to us about this today.
Cheers.
We really appreciate it.
No, thanks for having me.
And if you do have queries or questions about caveats, we do understand that they are very legalistic, and you may need someone to help you navigate your journey, either lodging a caveat or having a caveat removed from your title. Our OMB teams, both property and litigation, should be able to give you guidance along the way. And we look forward to seeing you again shortly on our next OMB Law Board.